So good morning again. But let me clarify one thing that now I am the moderator and I am the speaker as well. So your questions will not be, it will not be possible for me to read the questions and answer them immediately. I'll need time to read the questions and otherwise your lunchtime would be affected. So it is up to you. In case you have any questions, please do, you're free to ask them. But maybe I'll reply them in the next session after reading the questions.
Right, ma'am.
So they say that being single is smarter than being in the wrong relationship. Do you agree on that? Because we are talking about role of a judge in divorce proceedings. So we should understand the concept of divorce. But on a serious note, of course, there cannot be a second opinion on the point that the inflated rate of divorce in India is alarming. In case titled Gaurav Nagpal versus Sumedha Nagpal, that is 2009, Volume 1, SCC 42, Honorable Supreme Court has observed that it is a disturbing phenomenon that large number of cases are flooding the courts relating to divorce or judicial separation. An apprehension is gaining ground that the provisions relating to divorce in the Hindu Marriage Act has led to such a situation. In other words, the feeling is that the statute is facilitating breaking of homes rather than saving them. Of course, this may be too wide a view because actions are suspect, but that does not make section invalid. Section 13. Actions may be bad, but the section is not. The provisions relating to divorce categorize situations in which a decree for divorce can be sought for. But merely because such a course is available to be adopted should not normally provide incentive to persons to seek divorce unless the marriage has irretrievably broken. So this is where you have to interfere. Effort should be made to bring about conciliation to bridge the communication gap which led to such an undesirable proceedings. We all notice that mostly in divorce cases, it is the communication gap. The differences otherwise are very rare. People rushing to courts for breaking up of marriages should come as a last resort. And unless it has an inevitable result, courts should try to bring conciliation. The emphasis should be on saving marriage and not breaking it. This is more important in cases where the children bear the brunt of dissolution of marriage. It is very, very unfortunate that the concern about the child is not taken into consideration. We are in such a hurry to grant divorce to the parties. We are just gathering our units, collecting our units, and we forget that there are children also involved. So I think we should always take pains and try for a conciliation as a family court judge. Because the worst affected victims of divorce are probably the children, as the ladyship had also pointed out. The most traumatizing situation for a child is perhaps seeing one's parents getting separated. Being the constant witness to fights and an emotional turmoil among his or her parents is certainly an unfortunate circumstance for a child. As for a child, both of the parents are dear to him, and being away from one of them can hamper his emotional state of mind severely. This citation was cited by Ladyship also, Rosie Jacob versus Jacob A. Chakramakkal. This is AIR 1973 Supreme Court 2090, wherein it has been held that the children are not mere chattels, nor are they mere playthings for their parents. So in these circumstances, it has to be kept in mind that child is both the hope and promise for mankind. The greatest gift we can give our children are the roots of responsibility and the wings of independence. Often it is seen that in matrimonial proceedings, the interest of the child takes a backseat. In divorce proceedings, the parties are so engrossed in their bitter fights that the welfare of their own child is lost sight of. This is very unfortunate, but it always happens. It is here that the court must guide them. We as judges must guide them. We miss the most important aspect of securing the future of the minor child by ensuring that in the entire process, a reasonable amount of maintenance has been kept aside for the child. Since Section 13 of the Guardians and Wards Act categorically stipulates that the welfare of the minor is the paramount consideration, therefore, it is also the paramount duty of the court to ensure that while parting ways, the parents have taken all due care to secure the future of the child, and they must have a writing to that effect as well, be it in the form of fixed deposit, health insurance, insurance policies. I mean, whatever way the court deems it appropriate, but the court should ensure that the future of the child is secured in the matrimonial proceedings. The financial conditions of the parents and their affluence must also be taken into account, and it must be ensured that the amount left aside for the minor child is sufficient to cater to his future needs, depending on the affluence of the parents. It is also the duty of the court to verify about the self-acquired as well as ancestral properties of the parents and ensure that the share of the minor child in the said properties is secured in accordance with law. The interest of the child must be kept in consideration even if the mother is relinquishing her claim in the property of her husband. So we'll just discuss a few case laws where all these aspects have been considered. In Messrs. Jordan Diengde versus S.S. Chopra. This is AIR 1985, Supreme Court 935. Honorable Apex Court had suggested for a complete reform of law of marriage and to make uniform law applicable to all people, irrespective of religion or caste. It was observed that it appeared to be necessary to introduce irretrievable breakdown of marriage and mutual consent as grounds of divorce in all cases, because there is no point or purpose to be served by the continuance of marriage which has so completely and significantly broken down. But unfortunately, no such steps have been taken by the legislature so far, though directions have been issued in this regard, again in case titled Savitri Pandey versus Prem Chandra Pandey. That is AIR 2002, Supreme Court 591. Then in Manisha Tyagi versus Captain Deepak Kumar. This is a very famous case. AIR 2010, Supreme Court 1042. It was held that regard must be had to the social status, education level of the parties, the society they move in, and the possibility or otherwise of the parties living together before granting divorce. So the grounds of divorce we all know are enumerated in Section 13, which are adultery, cruelty, desertion, conversion, insanity, virulent and incurable form of leprosy, venereal disease, renunciation, presumption of death.
Ma'am, you are not audible.
Since when am I not audible?
Last sentence, ma'am. After Manisha Tyagi. After Manisha Tyagi case. Again, not audible, ma'am.
Am I audible now?
Yes, yes, now you are
Yes,
audible,
ma'am.
ma'am.
Okay. ठीक है. So in Manisha Tyagi's case, that I said that regard must be had to the social status and education level of the parties and the society they move in. And also the possibility whether there is they can live together again or not. So this is what has to be considered before granting divorce. I mean, divorce should not be given easily on the asking of the parties. There can be many repercussions. So we'll just come to the grounds of divorce quickly. As we all know, these are enumerated in section 13. Adultery, cruelty, desertion, conversion, insanity, virulent and incurable forms of leprosy, venereal disease, renunciation, and presumption of death. Now, adultery is a ground of divorce under Hindu Marriage Act, Divorce Act, Parsi Marriage and Divorce Act, and under the Muslim law. Adultery as such is not a ground of divorce, but husband's association with women of ill repute or his leading an infamous life is a ground of divorce. Under the original Hindu Marriage Act 1955, the ground was living in adultery. But now one act of adultery is enough to constitute a ground of divorce. Now, in case titled Joseph Shine versus Union of India, 2019, Volume 3, SCC 39, Section 497 IPC, which criminalized adultery, was struck down on the ground that the law was archaic, arbitrary, and paternalistic, and it infringed upon a woman's autonomy, dignity, and privacy. It was held that the provision violated Article 14, Article 15, and Article 21. Now, how to prove adultery? It can be proved only by circumstantial evidence, proof of husband's non-access and birth of a child, or proof of contagious disease in private part, and of course, admission and acceptance, which is very rare. Strict proof of adultery is not possible, and therefore preponderance of probabilities for such an act is sufficient. In case titled Rajinder versus Sharda, AIR 1993 MP 142, it was observed that mere intention to commit adultery is not sufficient. The act has to be committed. The offense of adultery, it was also observed in this case only that the offense of adultery may be proved by circumstantial evidence, by evidence as to non-access and birth of the child, contracting venereal disease, by evidence of visits to brothels, confession and admission, and preponderance of possibilities, probabilities. Then adultery can be proved by circumstantial evidence, but in case titled Parvati versus Shivaram, that's AIR 1989, HP 29, the court held that circumstantial evidence should be such that it should lead only to one inference, that is, the respondent has committed adultery, no other inference. Then we'll also talk about Section 112 Evidence Act, which provides for conclusive proof of legitimacy of a child born during continuance of a valid marriage. The only exception being that parties had no access to each other. Now, there was a case, Patta Dham Lakshmi versus Patta Ramchandra Rao, AIR 1998, AP 341, where the wife was living with parents and she became pregnant without resumption of cohabitation. It was averred that husband used to visit and stayed the nights, but fails to examine parents or any other person to support her version. In these circumstances, husband was granted divorce on ground of adultery because the access was not proved by the wife. So the burden of proof is on petitioner to establish that respondent committed adultery. Now we'll talk about adultery in Muslim law. Section 2, subclause 8b, Dissolution of Muslim Marriage Act 1939 provides that a Muslim wife provides a Muslim wife a divorce on the ground of adultery. According to the section, if the husband associates with women of ill repute or leads an infamous life, it would amount to cruelty and the wife can obtain divorce. Here it is the wife who can obtain the divorce. This is Dissolution of Muslim Marriage Act 1939. Then under the Muslim law, wife is entitled to sue for a divorce on the ground that a husband has falsely charged her with adultery. This type of divorce is called li'an and has been discussed. We'll not talk about it here because we don't. Did somebody say anything? Okay. Then adultery in Christian law. This is the Elu Jacob versus Mariama, AIR 1976, Kerala 89. This is section 10, L1 IDA, Indian Divorce Act. This provides divorce on the ground of adultery. When the husband or the wife petitions for divorce under this act, the petitioner should join the adulterer or adulteress as co-respondent. The reason for doing so is to satisfy the court that the petitioner has not made the application in collusion with the opposite party. If this is not done, then the husband's application would be dismissed. Then there is Anup De Silva versus Union of India, 2022, live law, Kerala 645. It was observed that the Indian Divorce Act was enacted during the British period in the year 1869 to confer certain courts the jurisdiction in matrimonial disputes. Certain persons who are professing Christianity. So by the Amendment Act 51 of 2001, the word Indian appearing in the Act has been omitted. Then the Law Commission of India in its 164th report recommended that the Parliament enact a comprehensive law regarding marriage and divorce and all other allied aspects of Christians in India. So based on this recommendation, central government had convened a meeting. Now, adultery is also a ground for divorce under Section 32D of Parsi Marriage and Divorce Act, and also under Section 27(1)(a) of the Special Marriage Act. Now, the most common ground that is taken is cruelty. So, cruelty cannot be proved until and unless there is physical cruelty. So it is a mixed question of fact and law. Any conduct which affects the health, fitness, reputation, work, etc. of the other party is cruelty. The apprehension of the applicant, if he comes to the court that there is cruelty, must be reasonable. Cruelty can be practiced by the wife over her husband and vice versa. I'm sure we are flooded with cases where the husbands allege that wife has been very cruel to him. Then we have to keep in mind that solitary instances of cruelty would not constitute cruelty so as to grant decree for divorce. In Shobha Rani versus Madhukar Reddy, AIR 1988, Supreme Court 121, this aspect was taken into consideration. It was observed that it will be necessary to bear in mind that there has been a marked change in the life around us. in matrimonial duties and responsibilities in particular, we find a sea change. So when a spouse makes complaint about the treatment of cruelty by the partner in life or relations, the court should not search for standard in life. A set of facts stigmatized as cruelty in one case may not be so in another case. The cruelty alleged may largely depend upon the type of life the parties are accustomed to or their economic and social conditions. It may also depend upon their culture and human values to which they attach importance. So we, the judges and lawyers, therefore should not impart our own notions of life. We should not import our own notions of life. We may not go in parallel with them. There may be a generation gap between us and the parties. So we have to balance everything. There's another case, Ravi Kumar versus Julmi Devi. This is Manu SC 0102 of 2010. So here it was observed that in matrimonial relationship, cruelty would obviously mean absence of mutual respect and understanding between the spouses, which embitters the relationship and often leads to various outbursts of behavior, which can be termed as cruelty. Sometimes cruelty in a matrimonial relationship may take the form of violence, and sometimes it may take a very different form. It may be just an attitude or an approach. At times, silence in some situations may amount to cruelty. Therefore, cruelty in matrimonial behavior defies any definition. Whether husband is cruel to his wife or the wife is cruel to her husband has to be ascertained and judged by taking into account the entire facts and circumstances of the case. And it cannot be defined in any rigid formula. It can be of infinite variety, and it may be subtle or even brutal, and maybe by gestures or words. So at times the wife may come and say that the husband remains silent. He doesn't answer. He doesn't say anything. That itself is cruelty, because in a husband and wife's relationship, matrimonial relationship, the mutual respect, the mutual care, that has to be there. In case titled Savitri Pandey versus Prem Chandra Pandey, AIR 2002, Supreme Court, 591. The two aspects of cruelty, that is physical cruelty and mental cruelty, were discussed. So physical cruelty, as per this judgment, consists of acts which endanger the physical health of complainant, and it includes the inflicting of bodily injury or giving cause for apprehension of such injury. And mental cruelty consists of conduct which causes mental or emotional suffering. So mental cruelty is conduct which causes and is intended to cause distress to one's spouse. It was observed by Lord Denning in a case titled Sheldon versus Sheldon, 1966 to WLR 993, that varieties of cruelty are never closed. Every case is a type in itself. So we have to remember this, that every case is a type in itself. Basics of cruelty depends upon conduct of a person, his capacity to suffer, and the surrounding facts and circumstances. In GVN Kameshwara Rao versus G. Jabili, 2002, Volume 2, SCC 296, it was observed that mens rea is not important. If an act or conduct caused mental cruelty, it was enough. I think there's some question. So I'll see that later, because I cannot see it right away. If I was saying that if an act or conduct caused mental cruelty, it was enough whether it was directly aimed at the petitioner or whether it was aimed at some near or dear ones of the petitioner. I mean, it might be aimed at the mother or the family members of the other spouse. So the act of cruelty need not be of such nature as to create a reasonable apprehension that it would be harmful for the petitioner to live with the other party. It is enough that the act of cruelty committed by the other party should be with an intention of causing suffering to the conduct that is complained and should be grave and weighty. Now, examples of cruelty have been specified in case title Dev Kumar versus Thilla Gawati, AIR 1995, Madras 116, where it is stated that continuous cessation of marital intercourse or total indifference on the part of the wife towards the marital obligation would lead to cruelty. The act is silent about the degree of cruelty, which needs to be proved in a matrimonial case. Degree can be to any extent. It all depends on the person to person, to what extent he can bear it or who he can inflict. Unusually callous, neglectful, and deliberately harassful conduct amounts to cruelty. False accusation of adultery or unchastity amounts to cruelty. False charge of impotency, undue familiarity with a person of opposite sex, deprivation of property, drunkenness, false criminal charge, refusal to consummate marriage, false complaints to employer, nagging, false, scandalous, malicious, baseless charges, demand for dowry, threat to commit suicide, humiliating the wife or the husband in front of family and friends. These all amount to cruelty. So in JL Nanda versus Veena Nanda,
Ma'am, again, you are not audible, ma'am. Since JL Nanda.
क्यों हो रहा है ऐसा? मैंने इसको click ही नहीं किया. I'm sorry, there's some technical issue. In case title JL Nanda versus Veena Nanda, AIR 1988 Supreme Court 407, it was held that the court has to look behind the allegations leveled by the party. And no presumption of cruelty can be taken simply from the allegations leveled in the petition. I mean, this is a very important role of the judge in a divorce proceeding. Then in KR Marionath versus Veena, AIR 1999, Karnataka 64. Husband had taken the plea of mental cruelty, but it was found that it was the wife who quarreled with the husband as he was having illicit relation with the neighbor. So here the divorce was declined because the fault was with the
Not audible, ma'am, again.
Again.
So the divorce can be declined by the court on the grounds of cruelty if wife's or spouse's own conduct is unreasonable. Then divorce can be declined. Where a spouse is provoked to cruelty or where violence or assault is used in self-defense, then unemployment of husband cannot constitute cruelty. Then temperamental differences do not amount to cruelty. So there's another ground, desertion. Now, desertion, we say that the person has left the company. But here we have to see that permanent abandonment of the spouse. It is the permanent. The intention has to be of permanently abandoning this spouse. Rejection of the obligation of marriage. It has to be without any reasonable justification. and there is no consent of another spouse. So desertion is not the withdrawal from a place, it is withdrawal from a state of things. Desertion must exist for a period of 2 years immediately preceding the presentation of the petition. Temporary abandonment of one's spouse in a fit of anger or temporary passion is not abandonment. In case titled Ravi Kumar versus Julmi Devi, I'll not repeat it, I've already. Am I audible?
Yes, ma'am.
Yes, ma'am.
Now, another ground is conversion. When the spouse has ceased to be a Hindu by conversion to another religion. So in Rekhia Bibi versus Anil Kumar, ILR 1948, Volume 2, Calcutta, it was held that it is open to court to go into question whether the conversion was bona fide one or a mere device adopted for ulterior purposes. I mean, as we commonly see, the personalities, they just convert and they get married. So it should not be a device adopted for ulterior purposes. Then insanity. Insanity is only the unsoundness of mind that cannot be cured. If the spouse has been suffering continuously or intermittently from mental disorder of such a kind and to such an extent that the party applying for divorce cannot reasonably be expected to live with him or her, then that is a ground. Mental disorder means incomplete development of mind, and it includes a psychopathic disorder and also schizophrenia. Now, psychopathic disorder means a persistent disorder or disability of mind which results in abnormally aggressive or seriously irresponsible conduct. Now, both can be a ground for divorce. Seriously aggressive, abnormally aggressive, or when the person is seriously irresponsible. When we say challa hai, I mean, he's not, he's a very innocent person. So that innocence is of no use to the wife, to the other spouse. So we have to take it into consideration that it is difficult. It cannot reasonably be expected by the other spouse to live with such a person who's too simple. Then only virulent and incurable form of leprosy is considered as a divorce, a ground for divorce, and not otherwise. Then in renunciation, when the other spouse has renounced the world by entering any religious order, then it is a ground for divorce. And venereal disease, we all know when the other spouse is suffering from communicable form of venereal disease, not otherwise. It is a ground for divorce. Then presumption of death. Of course, if a person has not been heard for 7 years, there is a presumption of law that he is dead. But at that time, within that, what period he died is not a matter of presumption, but that is a matter of evidence. And the onus of proving the death took place at a particular time is on the person who is claiming that the death has taken place. Now we'll talk about divorce by mutual consent. The sections I'll just quickly tell you under Section 28 Special Marriage Act, Section 32B of the Parsi Marriage and Divorce Act, Section 10A of the Divorce Act, and Section 13B Hindu Marriage Act. Here, in all the acts, a joint petition is required to be filed by the spouses, which we all know. Then the requirements are that the spouses have been living separately for a period of 1 year. It was 2 years under the Divorce Act. I'll just tell you the case law where it has been reduced to 1 year now. The parties have not been able to live together, and they have mutually agreed that marriage should be dissolved. Now, living separately, which is mentioned here, should be immediately preceding the presentation of the petition. In case title, Sureshta Devi versus Om Prakash, AIR 1992, Supreme Court, 1904. The concept of living separately has been discussed. So the Honorable Apex Court has said that the expression living separately means not living like husband and wife. It has no reference to the place of living. The parties may live under the same roof by force of circumstances, and yet they may not be living as husband and wife. The parties may be living in different houses, and yet they could live as husband and wife. So what seems to be necessary is that they have no desire to perform marital obligations. And with that mental attitude, they have been living separately for a period of 1 year, immediately preceding the presentation of the petition. So we should not confuse this that where the parties are living together, we may not, I mean, they're living in the same house. We should not decline the petition on this ground that they are living in the same house. It is just that the marital obligations are not there. So this is in Soumya and Thomas versus the Union of India and others, Manu /KE /0255 /2010. Where while declaring as unconstitutional the stipulation in Section 10A Divorce Act that the spouses must have been living separately for a period of 2 years or more, it was held that the stipulation of the period of 2 years violates the fundamental rights to equality and the right to life under Article 14 and 21 of the Constitution. So it was held that period of 2 years has to be read as 1 year. This was taking a note of 1 year period stipulated in all other sections, 28(1) of the Special Marriage Act, Section 13B of the Hindu Marriage Act, and Section 32B of the B1, of the Parsi Marriage and Divorce Act. So now the period of 2 years as mentioned in Divorce Act has to be also taken as one. Now, we all know that we have the power to waive off the cooling off period. But how and when it has to be exercised, that has to be kept in mind. In a divorce by mutual consent, there is a period of waiting of 6 to 18 months, as we all know. This interregnum was obviously intended to give time and opportunity to the parties to reflect on their move and seek advice from relatives and friends. In this transitional period, one of the parties may have a second thought and change the mind not to proceed with the petition. So in Amardeep Singh versus Harveen Kaur, the landmark judgment 2017, volume 8, SCC 746, Honorable Apex Court has held that cooling off period of 6 months is directory. It was held that as the period mentioned in Section 13B(2) is not mandatory but directory, it will be open to the court to exercise its discretion in the facts and circumstances of each case. So you have to see the facts and circumstances of each case, and where there is no possibility of parties resuming cohabitation and there are chances of alternative rehabilitation. So if a case is made out to waive the statutory period under Section 13B(2), the court can do after considering certain conditions, that is the statutory period of 6 months specified in Section 13B(2), in addition to the statutory period of 1 year under Section 13B(1) of separation of parties, is already over before the first motion itself. Then all efforts for mediation or conciliation, including efforts in terms of Order 32A, 32A Rule 3 CPC, Section 23, Subclause 2 of the Hindu Marriage Act, and Section 9 of the Family Courts Act to reunite the parties have failed. And there is no likelihood of success in that direction by any further effort. When the parties have genuinely settled their differences, including alimony, custody of child, or any other pending issues between them. Because otherwise the waiting period will only prolong their agony. So if these conditions are satisfied, that the waiting period will only prolong their agony, the parties have settled their disputes and the mediation has failed, and the statutory period of 6 months or that has already already over, then the cooling off period can be waived off, but it cannot be waived off in every case. You have your discretion. So the waiver application can be filed 1 week after the first motion, giving reasons for the prayers for waiver. If the conditions mentioned, which I've just informed you about, are satisfied, the waiver of the waiting period for the second motion will be in the discretion of the court, and it has to be kept in mind that the object of cooling off period of 6 months before grant of decree of divorce is only to safeguard against hurried decision. The children these days, the younger generation is, if you must have realized this, that they actually act in haste and they regret later. In one of the cases in my court, they took divorce by mutual consent, and few days later they moved an application for cancellation of divorce. So that is the purpose of the cooling off period, is to give ample time to the couples to reconsider their request for judicial this divorce. But the object is not to perpetuate purposeless marriage or to prolong agony of parties where there are no chances of reconciliation. In those circumstances, I think we should all grant divorce to them if they cannot live together.
Excuse me, ma'am.
Yes.
Ma'am, because the question is linked to this part. Ma'am, now we are getting applications for the exemption of even the 1 year statutory separation period. Just like the parties are married in, let us suppose, in March, so they'll move an application in July itself.
This is what I said, until and unless the waiting period will only prolong their agony, you have to see the circumstances. Otherwise, you have to comply with the conditions which are mentioned in Amardeep Singh's case.
Okay, ma'am.
You should not, the purpose of the family court is to bring about conciliation. If the parties are acting in haste, I mean, in 2 months, you cannot even know each other. How can you know that, how can you realize that you cannot live with that person? You've not known the other person. I mean, once there was a petition in my court where the lady said that she was not allowed to wear jeans in her matrimonial house. So she came for divorce within 2 months. And the mother-in-law was present there. She said she'll permit her, but initially you have to understand, you have to adjust. So I think it is better to give time to them. You should dismiss such applications where the parties are acting in haste and you feel that there is actually no ground to justify their decision.
And ma'am, in case they regret for their decision, then they will have to remarry or they will have to apply for cancellation of divorce.
There is no provision for cancellation of divorce. So they'll have to remarry. And that is I think a very, that is making mockery of the whole institution of marriage. So that is the whole purpose, that we should give them time, let them reconsider. If they are living separately from each other, they get to know whether they actually miss the other person, whether they understand the meaning of marriage. So the whole purpose of the family court is to bring about reconciliation instead of aiding and abetting the haste decision that has been taken by the spouses. The millennials, as we call them, they are not aware of the consequences, repercussions of divorces. And they feel life would be easier. They would be able to achieve so much if they take a divorce. But here we have to interfere. We have to see that the balance is maintained. The society remains, I mean, we have to maintain a balance. I mean, we have to defer their hurried decisions. if we feel it's a hurried decision. There's a case law. This is Jay Shankar and another versus Nil. The name has not been disclosed. This is 2021 SCC Online Madras 708. Here, the revision petitioners had referred the petition on the file of the Family Court under Section 13B of the Hindu Marriage Act. Husband and wife had been living separately for 13 years and mutually agreed to dissolve their marriage. The Honorable High Court concluded that the parties had been living separately for 13 years and had entered into a compromise. Along with this view, they referred the matter to the Family Court and with the direction that the cooling off period shall be waived off. Here, if we again say that 6 months period would be required, they have already suffered the agony. They have already lived apart for 13 years. They know what they want. And the reconciliation is absolutely not possible. So in these circumstances, we can always waive off the cooling off period because no purpose would be served. Then the consent that is given in a divorce proceeding should be free. The judge has to ensure that the consent should be free from force, fraud, or undue influence. It is the duty of the, see, there's a case, Anuradha Samir Venangot versus Mohandas Samir Venangot. This is 2015, volume 16, SCC 596. In this case, the wife was suffering from cancer and she agreed to divorce by mutual consent in consideration of rupees 12.5 lakhs as full and final settlement, which she needed for her own treatment. So the court has held that it is the duty of the spouse to take care of the health and safety of the ailing spouse. So in this case, the court held that the husband had not fulfilled his pre-existing duty, and therefore this was not, the amount that was given was not a valid consideration and the consent was not free. Then we often see that appearance of parties through duly constituted attorneys. So the paramount thing which is required to be considered by the court is correctness of contents of the petition filed, and also to see that consent of either of the parties is not obtained by way of force, fraud, undue influence. But in the absence of the parties where the attorneys appear, the courts have to be more cautious and vigilant in recording its satisfaction about the consent. You can note down a citation in this regard. This is Navdeep Kaur versus Mohinder Singh Ahluwalia. This is 2010, volume 2, Marriage Law Journal, Punjab and Haryana. Page number is 400. Then, consent cannot be presumed by the absence of the party. So if the party is not appearing after 6 months cooling off period has lapsed, then the court is not supposed to presume that the party has consented. So before passing a decree of divorce, the court remains under an obligation to satisfy itself as to whether the consent given by the parties is a valid one or not. In Ramola Mandir versus Charanjit Singh Mandir, 2015, volume 3, Law Herald, 2556, it was held that where one of the parties is absent during the course of second motion, the trial court should afford at least one opportunity to the party. One opportunity should be given to that party to appear for second motion before dismissing the joint petition as the same is moved jointly. So the only course that you have is either you dismiss that petition because the other party is not present, or you issue a notice to that person to appear before you. If the person is still not appearing, then that joint petition for mutual divorce becomes null and void because the one party has apparently withdrawn its consent. We should not presume that he has given his consent by not appearing. He should come in the court and give his consent. So in that event, we will dismiss the joint petition and the aggrieved party will file a petition under section 13. The party, unless there is a complete agreement between husband and wife for the dissolution of marriage, and unless the court is completely satisfied, it cannot grant a decree for divorce by mutual consent. You can note a citation also in this. We have Avnish Sood versus Tithi Sood. This is an important case. 2012 SCC Online 2445. Then there's another one, Gagan Sethi versus Shilpa Sethi, 2013 1 HLR 490. It says that withdrawal of consent on second motion by wife does not amount to making false statement or resiling from first statement so as to amount to cheating. We cannot say that she was making a false allegation earlier or she had made a false statement in the court. That is the purpose of having two statements is to give time to the parties to reconsider their decision. And if one party is withdrawing the consent, then that party has not made any offense and that party cannot be punished in any manner. The parties have a right to unilaterally withdraw their consent at any time till passing of the divorce decree. In Anil Kumar Jain versus Maya Jain, 2009, volume 10, SCC 415, it has been held that normally consent of parties should subsist till passing of final decree of divorce. Now the question is that at times after the first motion.
Ma'am, can I put a query?
Yes.
Can I put a query, please?
Yeah, sure.
Ma'am, if during the course of the first motion, some money or some property has changed hands.
That is what I'm going to answer, tell you.
Thank you. Thank you, ma'am.
Exactly, that is what I'm telling you. That after the first motion, at times, some money has already been transferred to the wife or some property has been given to her. So in case it is the duty of the court to seize of such dispute to restore parties to the position on the date of filing the petition. If the party that receives money retracts from mutual consent, such a party would be required to restitute the amount so received. In this regard, you can read Deepak Singh versus Pooja, 2016, volume 2, RCR Civil 742. This is Honorable Punjab and Haryana. Then there's another case. This is Ravinder Kumar versus Rekha Rani, 2016, 182 PLR. This is 461. Here it was held. I'll just read it out. Jurisdiction to make restitution is inherent in every court and is to be exercised whenever the justice of the case so demands. A litigant cannot use the process of court so as to surreptitiously obtain a benefit on the representation to do a certain act and thereafter retract from the representation that had been, retain the benefit by taking a different, changed and a contradictory stand. So in this case, wife had received an amount of a certain amount on the presentation, on the representation that she agrees to give divorce at the time of first motion of the proceedings of the joint petition. But later on, she refused for divorce on the second motion. So it would necessarily imply that the benefit of whatever amount she had received on her representation has to be refunded and restored.
Ma'am, may I put one question?
Yes.
Ma'am, sometimes what happens that before filing of divorce petition on the ground of cruelty, immediately before filing of petition, one settlement or compromise is also appended with the petition, stating therein that we have taken a panchayati divorce. So in that divorce, panchayati divorce, in fact, they mention that we have settled all the disputes and now there is no dispute between us. Whether it will be considered to be condoning the cruelty? If divorce petition is filed on thereafter on the ground of cruelty, whether we have to consider that the act was already condoned and now no divorce can be granted on the ground of cruelty.
See, then they'll have to file a divorce for mutual consent. It is for the parties to level allegations. We just have to see
No,
whether the allegations are genuine or not. We
No,
cannot.
Ma'am,
The
with consent
panchayati.
only is possible under section 13B. After
Yes.
after that the settlement out of the court, they come to the court under section 13 on the ground of cruelty, and immediately before filing of petition there is a settlement in which they have stated that we have settled all the disputes, and thereafter one of the parties resiled. And if there is a condoning before filing of the petition and the panchayati divorce is there, then in that case, on one hand, we have to think that parties are in fact parties were wanting divorce. Now, whether that has to be considered as condoning or not.
We again have to see whether the consent of the party who had retracted was free from any force, undue influence or fraud. There might be a possibility that the wife was illiterate and she was
Then they-
forced to sign that panchayati agreement. So you have to see, we cannot have a rigid formula for in this regard. You will have to consider what were the aspects. That is why it is said that you have to go behind the allegations to see what are the circumstances of the families, what is their education, what is their state of living, economic conditions, whether they are whether such a allegation can be possible or not. So we have to see everything. We cannot just straight away say the panchayati divorce, of course, is of no consequence.
Not with
But
no,
the
no
allegations.
legal effect.
But if the person has retracted, one of the spouse has retracted, we have to see the reason. She might have explained that it was given, she was forced to sign. She was compelled to sign. It was a fraud. It was undue influence. Like I mentioned that the lady had to get herself treated. So she needed money for that treatment.
That's not basically a specific performance of that agreement. Basically, the party comes on the ground of cruelty thereafter. Either they have to ask to the court to perform, ask to the other party to perform that agreement and to give divorce. That's not there. The party comes on the ground of cruelty, that the other party has treated me with cruelty, and ultimately that settlement is also appended. So in that situation, the position becomes whether after taking into consideration that settlement, whether we have to take that before filing of this petition, you have already condoned the act of the cruelty.
See, that is if that agreement was signed voluntarily by the party who is now alleging cruelty. But of course, if
They
the
are not,
person is,
ma'am, they don't come on the basis of it. Hanji, please.
You
Excuse
say
me,
that-
ma'am.
Yes.
Ma'am, I think the burden would be on the party filing the petition to prove that the agreement was voluntary.
Yes, definitely. That is what I was going to say. That if the person has retracted from that agreement and now is alleging cruelty, then of course that panchayati agreement, you will have to see whether it was voluntarily signed by her. If it was voluntarily signed, the circumstances show that it was voluntarily signed by her, then of course the allegations of cruelty will be diluted by that panchayati agreement, not otherwise.
Meaning there, okay, that's done. Okay, ma'am. All right, ma'am. Thank you.
So I'll now quickly tell you about another case law, Vikas Verma versus Harpreet Kaur, 2016. 1 Law Herald 688. This is also on the same aspect. Now, I'll again repeat that withdrawal of consent in second motion shall not attract contempt proceedings. This is mentioned in Avnish Sood versus Tithi Sood. You just noted it down. It is only that the amount has to be paid, returned. Because the court says that once the respondent has taken advantage of the agreement between them, then he cannot be permitted by the respondent to withdraw his consent at his whims and fancies to the detriment of the petitioner. You have to see if detriment has been caused to the petitioner, then of course you will have a different view. But if no detriment has been caused to anybody, then there is no contempt. The consent can be withdrawn.
Ma'am, if the party fails to restitute despite instructions of the court, what could be done?
I'm
in
sorry,
that case?
can you repeat it?
Ma'am, if the party fails to restitute what has been taken by the directions of the court, what can be done?
This is discussed in Dinesh Gulati versus Ranjana Gulati. This says in this case, recourse to contempt proceedings against the respondent wife by the appellant husband was taken on a grievance that despite a mutual consent. Here, you know, it was if the amount is not restored, then the suit can be, the petition can be, it was held that such an order of initiating suo motu contempt proceedings neglects the mutuality aspect provided for under section 13B of the Act. And once the parties were unable to or do not wish to proceed with the agreement for mutual consent, then the only recourse was to restore the original divorce petition.
And then the only remedy available with the
Contempt
parties given the
proceedings
amount
can
would be
be
filing a suit for
yes, if the other
suit
person.
for recovery.
No, you have to direct the parties. You can always take those, your order has been violated. So you can always take whatever action. You have to tell the party to restore.
Right, ma'am.
Whatever amount. So you have to see what is appropriate. Then the power of attorney. Whether the parties can record statements in second motion through attorney. It was held in Jasprit Kaur Dhaliwal versus Kulvinder Singh. This is Law Finder document ID number 749017. It was held that where trial court did not doubt the bona fides of the party or legality of the prayer for dissolution of marriage. The two things have to be taken into consideration: bona fides of the parties and legality of the prayer for dissolution of marriage. It is not necessary to insist upon the personal presence of parties, particularly where parties admittedly resided abroad, because that would perpetuate injustice, wastage of time and money. So second motion, but this was second motion. So in second motion, the court held that trial court should not insist upon personal presence of the party to record statement. But see, this is only exceptional circumstances, not in every case. In this case, the party was living abroad and it would have been just incurring an unnecessary expenditure to come. This statement can be recorded through video conferencing also, but the person who is, the court has to be satisfied that the power of attorney is genuine. He is a close relative. Through close relations such as parents or siblings. That is only in exceptional circumstances. Please don't make it a habit. Otherwise, no husband or wife will come to the court. And the very purpose of Family Courts Act is to ask the parties to appear in person. This was discussed in Amardeep Singh versus Harveen Kaur also. That courts have been permitted to use the medium of video conferencing. But I'll again repeat, there is another citation, Santhini versus Vijay Venkatesh, 2018-1, so SCC 62, where the validity of proceedings conducted through video conferencing by the family court was taken into consideration. The matter was referred to the larger bench for consideration, and the larger bench in the citation 2018, volume 1, SCC 1, per majority view held that physical presence of both parties in matrimonial proceedings, which are held in camera, is essential as it creates an environment of trust, confidentiality, privacy, and emotional bond. So this is the majority view in Santhini versus Vijaya Venkatesh. So therefore, you should insist on the personal appearance of the parties and should not resort to video conferencing of the material witnesses or the parties till it is very essential, and in that case, you will have to give your reasons. In divorce by consent under Muslim law, which is Khulla or Mubarak, it is essentially an act of the parties and no intervention by the court is required. So what I would like to bring to your notice is Section 23 Hindu Marriage Act. This is a very, very important provision. This has to be kept in mind while deciding all the petitions. And what does Section 23 says? Petitioner is not taking advantage of his or her own wrong or disability. He has not connived or condoned the acts complained of. Consent in mutual divorce is not obtained by force, fraud, or undue influence. Petition is not collusive. No unnecessary or improper delay in filing petition. No legal ground to deny the relief. So before proceeding to grant any relief under this act, under the Hindu Marriage Act, it shall be the duty of the court to make every endeavor to bring about a reconciliation between the parties. This is what you have to keep in mind. Section 23 Hindu Marriage Act. Aapne dekha hoga in the petition, it is always mentioned in the end that there is no condonation, condoning and is not condoned, no unnecessary or impeding delay in filing petition, etc., etc. All these grounds have been taken. But even while deciding the petition, you have to take into consideration whether the allegations which are leveled are not due to the fault of the person who is leveling the allegations. So I think jurisdiction, of course, you all know, it is Section 19 of Hindu Marriage Act. So I'll not, because we're already running short of time and you will have very less time for having your lunch. So I'll end this talk here only.